Henshaw here again with another um, news update. And this one I feel a little embarrassed about because I was going to do it the last time and I got so out of sync that I forgot that I hadn't done it. But it goes to the Oakland case that many of you know that I've been working on for a while, the current Oakland case. And we had a hearing there on January 28th. And I haven't seen anything like that since I was by myself in Columbia, South Carolina. This kid came in and just did a job and shutting these people down and finally had a chance to talk at least a little bit. And at the moment, at that time, he was again, and he said, by the way, himself appearing in proprietary persona, and the black robe bastard and the local dumbass agreed to that and said on the record in proprietary persona. And the dumbass admitted that he had not answered the bill of particulars. This is 7 months later. In theory, a BOP should be answered within 2 weeks, maybe 4 weeks maximum, because the bill of particulars, for those of you that don't know, and you can learn by picking up my modestly priced constitutional defense document packets, send me an email at youwinnincourt@gmail.com. And this bill of particulars is a killer. Without more, this wins most cases because what you're asking them to do is identify the nature and cause of the accusation, otherwise known as the jurisdiction and venue of the trial court, and the rules of the con game. Not to mention, identify the elements of the crime so you'll know what they have to prove in order to get a conviction, and the identity of the injured party so that you can invoke your uncontested right of confrontation and cross-examination. You know, there's a lot more to it, by the way, the way I do a BOP, as you'll see, but these basic elements are clearly recognized, if only under the Sixth Amendment. And by the way, I never use that per se. If I use the Sixth Amendment, I say the unpurviewed Sixth Amendment. The 14th Amendment has nothing to do with it. Not only does the 14th Amendment not exist, but we're in territories. And the Bill of Rights applies in territories. So this BOP, if you don't know any of these things, what I just said, jurisdiction and venue, elements of the crime, identity of the injured party, if you don't know any of this, how the hell are you possibly going to put on any meaningful and substantive defense? Why bother to have a trial? Get it over with. Guilty. Of course, the problem they may have with that, and I think I said it before, if I can find any of the survivors of Joseph Stalin, is that his survivors would have claims for copyright infringement for stealing his trials, what they used to do over there. You know, put a gun to your head and get a confession out of you, and then claim you confessed, and then take you out in the yard and shoot you or hang you, as the case may be. But if we don't know this information, this is reversible error. And yet, in now my 5th decade, I have never had any of my documents, especially a bill of particulars, even acknowledged, let alone answered. What does that tell you? That tells you if they identify the jurisdiction of the trial court, it's going to have to be either admiralty, and that's the jurisdiction, by the way, foreign to our Constitution and unacknowledged by our laws, which state courts aren't allowed to exercise, or federal regional martial law rule, and they can't do that either in times of peace. And even in times of war, it would be limited here. There would be rare exceptions, but even in wartime, it would be limited here. It's just the way the Constitution was set up, and they did a great job of doing that. So they can't answer, and if they identify the elements of the crime, they have to, in effect, admit they're all commercial crimes. That's admiralty jurisdiction, which again they can't exercise. And the allegedly injured party, we don't have a clue who that is, especially in the traffic cases like that where you're charged under statutes. There's no way to know. So what I'm doing, by the way, with the subpoena packet I'm developing is we're going to take the position, for example, that the head of the DMV in California is the injured party. And we're going to be sending him a letter that you'll get with my document packets long before you ever get to this state and say, guess what? We got a few questions for you here along the lines of the Bill of Particulars, but the record shows that we can establish this. I have so much relevant and admissible evidence here, you can't stand it. that they're never being answered by the local dumbass. Therefore, if you're, the injured party, you're the ones making the accusations against me that I am, for example, a 14th War Amendment citizen, which is what I call them, that I'm subject to the jurisdiction of the United States, I'm an artificial corporate entity, and that I have no rights by which the de facto government is bound to respect. And I want to know the factual foundation and legal basis for that determination. And you're going to produce it with what's called a subpoena duce tecum, bringing all the documents you used to make that conclusion, and or if you were instructed by the governor pursuant to his duty to see the laws are faithfully executed, and he instructed you like that, we sure as hell want to see that, because that governor is going to be out of a job and maybe in the pokey. You simply can't. It is not how it works here. It just isn't. So anyway, it's a background to the Oakland case. This is all that's going on here, and the DA admits in open court 2 months later they haven't answered the BOP. And that's reversible error. It can't be anything other than that. And yet all of our efforts to this point to get relief, have been forestalled. We're working on getting into the federal court, by the way, a removal petition that I'll report back on next time. And we're going to do a motion to dismiss, a new motion you'll be getting in my document packets, for want of speedy trial, because we're taking a position, and there are some states, Wisconsin is one, South Carolina is another, where the party is actually the state of Wisconsin. If that's the case, Article 3, Section 2 of the Constitution, what does it say, people? Direct quote, in all cases, ALL, in which a state shall be a party, the Supreme Court has original jurisdiction. Meaning that the jury trial, if there is one, would have to be in Washington, D.C. So we're making a motion based on Article 3, Section 2, and saying, number one, this court can't possibly provide a trial that it doesn't have jurisdiction to make. So dismiss it now, be done with it, or in the alternative, transfer the case to the 904 to put it in their original jurisdiction, and we'll have the jury trial there. Or get out from under altogether, dismiss the charges, be done with it. Simple. Nothing hard about it. So that's what we're trying to do here. So that's another thing we're doing. And we're on the verge of filing or attempting to file a complaint with the local U.S. attorney for treason to a lot of official actors. And in this Oakland case, this is the beauty. If you take the time and effort, like my friend has in the Oakland case, and study my materials, set the record, and learn to get in there in court and be just as forthright as he was, it scares the hell out of them, and it sets an unopposed record we can come back with to bite them in the ass after the case is settled, and get not only a huge settlement, but hopefully force them to change the way they do business so this stops happening anymore. Enough is enough. 150 years here. How long does it take? So that's what's going on. That's what's going on with that. And the other thing I don't get with this whole case is what the local dumbass over there, Nancy O'Malley, is doing. And they refused to meet with me. And they got 800 pages back in August. The first week I was involved in this case. 800 pages. And they're still... I've just never seen this level of ignorance. Well, I had with the defense attorney in the same case, by the way. We interviewed this stupid bastard. You've never seen anybody as ignorant as this and couldn't care less and thinks they don't have to care. And the big deal here, by the way, and I'll do a separate video on this in another occasion, but the State Bar Association out here, the only way they can sanction their attorneys for failure to do their job is if they violate the Business and Professions Act, which is an enactment of the California legislature in 1928, or they violate the rules set down by the California Judicial Council. All of that crap comes under the 14th Amendment. In other words, they can do exactly what's happening to my friend in Oakland. They violate every right that you have under all 6 articles of the Constitution. Not a damn thing the State Bar can do to help you invoke your rights. And that's the way it was planned. That's an admission and confession. that you don't have a right to assistance of counsel the way they see it. And yet the Supreme Court has said, you gotta love it. August thing would be Hamlin 407 U.S. 25, I think, page 40. That let each judge know at the start of a misdemeanor trial, let alone felony, that no jail time can be imposed though local law permits it when the accused was not represented at trial. This kid's going to never have had any representation in Oakland, and even if they go to trial and get a conviction, they can't send him to jail. So my question to you, Nancy O'Malley, is what the hell are you doing over there? Isn't it worth your while to give me 10, maybe 15 minutes of your time? We can get this whole matter put out of the way. God, that's simple. I don't see what the problem is. I'm going to come over at any convenient time. It's a bit of a trip for me, but I'll make it and resolve this case, get it done. Yes, there's going to be consequences, no question about it. If you read the papers, any of them, you're going to know that. You're committing acts of treason to the Constitution here that you simply can't do. Don't you have you sworn an oath to be bound by this Constitution and the laws enacted in pursuance thereof? Do you have any idea what the hell that means? And if not, what kind of a job qualification is that for the position of honor, profit, and trust that you're in this de facto government? None of this is hard. Case should have been over by the latest September, and here we are, March. How are you going to explain that to an already inflamed jury if I get your ass on the witness stand and start asking you questions like this? Not going to happen. There's no way you can do it. You know you can't go to trial. You know you haven't intimidated this kid one bit. What's the problem? Cut your losses. Get the case over with. Act in good faith for once. Is it really that hard to do? Damn. Yeah. Well, with a little luck, maybe next time you run for election, you'll be over there in Pyongyang. The skill set is much better suited there than it is here. Trust me. But again, if you want to contact me, send me an email, youwinnincourt@gmail.com, which is something, by the way, that you never do. You haven't done it once in the entire time you've been there. But send an email of that and check out some of my videos on my website. I mean, a lot of attorneys in that courtroom were doing it. They know me as a YouTube guy there. If you haven't been listening, maybe you should be. Get this case over with. Get this kid back home to his family. There's nothing hard about it. I mean, even if he did something, and we don't know what it is, we both know it doesn't matter. If the court doesn't have jurisdiction, you don't get any further than that. It doesn't matter what happened or did not happen. Wow. I've been banging my head against the wall. I know the people are frustrated with this case. They should be and they have to be, but we've done everything right. And not a damn thing has registered. With a law school education, you would think 4 to 6 years that something would have gotten through there. Wow. Anyway, contact me at your earliest convenience. youwinnincourt@gmail.com. And we'll have an update on this one the next time and see if we have any developments in the case to get this kid out of jail. Meanwhile, like my videos, subscribe, tell your friends, and thank you for listening.